Well, good morning, everybody. Thank you for joining us. Thank you for joining the Administrative Law Section's presentation on judicial review of administrative decisions. My name is John Grimm. I'm on the Section Counsel for the Administrative Law Section. We have quite a lot of material to cover, so I'm gonna just make a couple quick introductory remarks and then we'll get into it. So we have a very distinguished panel today. We're very lucky to be joined by Judge Andrea Leahy on the Court of Special Appeals, who writes and speaks extensively on topics of administrative law. We have Judge Kathleen Cox, who recently retired from the Circuit Court for Baltimore County, where she spent the last 10 or so years as the administrative judge. We have Meghan K, who's a partner at Gallagher, Evelius & Jones in Baltimore. Meghan's also a former Assistant Attorney General in the Civil Litigation Division at the Maryland Attorney General's Office, where she handled lots of administrative appeals. We have Shiva Goel, who's a partner at Harris, Wiltshire, and Grannis in Washington, D.C., where he does, his practice includes a lot of work in federal agencies, particularly the FCC. And I am also a partner at Harris, Wiltshire, and Grannis, and a former Assistant Attorney General in the Civil Division. And so collectively, this group has lots of experience with federal and state administrative appeals. And so we are going to get right into it. Just a quick logistical matter in terms of questions. We are going to try to save questions for the end. If you do have a question during the course of a presentation, please feel free to use the chat feature. I'll be monitoring that. And so if there is a question that makes sense to interject, I may field it as it comes in, but we're generally going to try to keep questions to the end. So with that, why don't we get started on our first topic, which is initiating judicial review in Maryland and federal courts. So I should be sharing my slide. Angela, do you see my PowerPoint slide?
Yes, we do.
Great. Okay, so we're gonna jump right into this and talk about how you begin judicial review of an administrative agency decision. And this is gonna be a comparison of the federal and Maryland approaches. As you will see throughout, the Maryland and federal approaches are pretty similar until they're not, and then they're pretty different. So this is gonna try to give you sort of a broad overview. The one major takeaway I think that we would hope that you leave with is there is never there is no one answer for how you get your case into court, and you need to always check the statutes and the rules, because there's not an easy rule like there is filing an appeal from the circuit court, which is file a notice of appeal and there you go. It's complicated, and so if nothing else, we want to impress upon you the potential pitfalls and the need to really think carefully at the beginning of your case what the path to court is. So, quick note on terminology. As a theoretical matter, and it really is theoretical, all administrative agency action falls into two categories. It's either a rulemaking or an adjudication. Or in the Maryland system, it's called a quasi-legislative action versus a quasi-judicial action. We will touch on what those mean, but you can generally think of them in very general terms. Rulemaking is when an agency puts out regulations, and an adjudication is pretty much everything else an agency does, whether it's a formal dispute resolution, whether it's the decision to award a license, whether it's a declaratory ruling construing an earlier rule. The distinction sometimes is very important and sometimes it's not so important. It can determine the procedure the agency is supposed to follow. It can determine the standard of review. It can determine the path to court. And sometimes it doesn't really make a difference. And so we're going to try to walk through some examples of when it matters, when it doesn't, and what to keep an eye out for. Let's see, Megan, were you gonna, I think this was Megan's slide.
I actually thought you were going to do this one, John, if you don't mind.
Okay, yeah, you can see how well we practice this. This is a quick comparison of Maryland and federal, the Maryland and federal approach. As we all know, federal courts are courts of limited jurisdiction. They have the jurisdiction that Congress gives them, which means that they don't have inherent authority to review administrative agency decisions. They do have pretty broad statutory authority, but you need to figure out where that statutory authority is. We'll talk about some of the places where you might find it. It can be in the Title 28 of the U.S. Code. It can be the agency's organic statute, or it can be an invocation of the court's federal question jurisdiction. The bottom line is getting into federal court with an agency decision can be highly variable. You really need to go sort of on an agency by agency or even decision by decision approach to figure out, for this specific agency, for this specific decision, how do I get into court? And we'll walk through how that works. Maryland has a little bit more uniformity in the sense that the review always begins in the circuit court. And that's partly because even though we talk about administrative appeals, these are actually original jurisdiction proceedings. And so under the Maryland Constitution, the circuit court is the court that hears those. However, the specific procedure that you invoke to get into court is going to depend on what type of agency decision is being challenged. And there is both statutory and inherent authority for the courts. Couple commonalities. As I mentioned, it's not technically an appeal. It is an original action, although it is it's fair to think of it as an appeal because a court is reviewing the legal decisions of an agency. It's similar to the way a court would review a lower court, and you're filing briefs and arguing the same way you would an appeal. The standards of review under both Maryland and federal law are similar, and there are similar concepts of deference to agency interpretations. Maryland's deference is a little bit, I would say, deference light. Federal deference is very sort of almost codified, even though it's all a function of case law. Maryland kind of borrows the same deference concepts as federal court, but it applies them with a little bit of a lighter touch. And then here are some key questions that you need to be thinking about when you're when you're beginning your appeal. Is it a federal or state agency? Obviously, that's going to determine if you're going into federal or state court, and it's going to determine what set of rules you need to look at. Which court can hear my case? That's going to depend on, again, if it's federal or state. It's going to depend sometimes on the agency, sometimes the type of decision. How is the agency action characterized? That is it a rulemaking or an adjudication? And what's the standard of review? And from a litigator's point of view, what standard of review do I want the court to be applying? Because that might influence whether you argue that it's one type of decision or another. So I'm going to cover how you get into federal court. And we're going to talk about the Hobbs Act. And no, it's not that Hobbs Act. This is not the fun federal robbery statute. This is a different one. This is the Administrative Orders Review. This is a federal statute that provides for review of certain agencies, which I've listed here, really just to demonstrate that there's no real rhyme or reason. You got the FCC, the Department of Agriculture, the Department of Transportation, the Federal Maritime Commission, the Atomic Energy Commission, which I'm not even sure if that exists anymore, the Surface Transportation Board, and then certain orders under the Fair Housing Act. These decisions of these agencies are all reviewable in any of the federal courts of appeals, except for the Federal Circuit. So final orders of these agencies are reviewable in the federal courts of appeals. However, as you'll notice, that this is a very, very small subset of federal agencies. So if you're not lucky enough to be challenging one of these agency decisions, where do you go? So this gets us to non-Hobbs Act review, and the short answer is you really have to look carefully, sort of all over the place. You need to look in the organic statute creating your agency, because that's probably going to tell you where the appeals go. And what's interesting is that there can be some very subtle distinctions. So one that we encounter a lot in FCC practice is, even though most FCC orders are reviewable in any federal court of appeals by filing a petition for review within 60 days, a very limited subcategory of FCC decisions can only be appealed to the DC Circuit by filing a notice of appeal, not a petition for review, within 30 days. So that is a very significant difference in the jurisdictional deadline for filing your case. So you need to be very careful to know if you fall into this small category of FCC decisions, it completely changes the way that you get into court. So whether the review is under the Hobbs Act or some other statute, review in the appellate court is governed by Federal Rule of Appellate Procedure 15. Unlike a notice of appeal, which really just says, I am appealing this decision, petition for review contains more information and is filed in the appellate court, not in the agency. Check the local rules very carefully. The DC Circuit in particular has lots of requirements for these cases because it hears so many of them. DC Circuit brief looks unlike other briefs. It has all kinds of sections that you don't normally expect to put in a brief, and it's an easy way to get your brief bounced if there's a problem. Review in district court. So, oh, I'm sorry, I skipped. Yeah, scope of review. Okay, 5 USC 706. This is the federal APA, Administrative Procedure Act. The APA gives, it establishes the scope of review, but it doesn't actually give a cause of action. The cause of action is determined by the other statutes I was describing. But these are basically the bases that a court can use to overturn an agency decision. I'm not going to go through these one by one. The arbitrary and capricious standard is the most famous. It's probably the one that gets invoked the most frequently because it really is a challenge to the agency's thought process and the reasoning that goes into the agency decision. So you can fit a lot of different arguments into that category. But essentially what we're looking at is various, an assorted variety of ways in which an agency action is contrary to the law. So you'll want to look at this and figure out which scope of review factor is the one you want to apply. Interestingly, in the federal system, these standards of review apply whether it's a rulemaking or an adjudication. As we'll see in Maryland, the standards of review for quasi-legislative and quasi-judicial decisions are a little bit different. Finally, we have review in district court. So even though I just spent the previous 10 minutes or so discussing all the different courts of appeals, the actual default forum, when there's none provided by statute, is the district court. So I mentioned earlier that federal courts don't have inherent authority to hear administrative appeals, which is true, although federal courts all do have statutory authority to hear federal questions. And so failing any other statutory provision for challenging an administrative appeal in court, you can bring a declaratory judgment or injunctive relief action in federal district court, invoking the court's federal question jurisdiction as a way of challenging the agency's rulemaking. So that's a quick overview of how we get into Maryland, into federal court. I'm going to hand it over to Meghan now, who is going to walk us through the corollary procedures for Maryland court.
Great, thanks, John. So how do you initiate review of an administrative agency decision in Maryland court? John, if you go to the next slide. Thank you. So unlike in federal court, all judicial review proceedings brought in Maryland start in the circuit court in the same place. So there's no question about where to begin. If you are aggrieved in the outcome of the circuit court decision, whether you are the petitioner or the agency respondent, you can typically, but not always, seek further review in the appellate courts. The Maryland Courts and Judicial Proceedings article, section 12302, states that you can seek further appellate review where it is expressly granted by law. The Maryland Administrative Procedure Act, Maryland APA, which is cited here at 10-223, provides explicitly for further appellate review for contested cases. And when that happens, the appeal process is the same as for any other civil case in Maryland. In other words, it's governed by Title 800 of the Maryland rules. But if the agency's decision isn't governed by the APA, if it is instead taken under, for example, a local ordinance or charter, you have to look to that statute to see if it authorizes a right to appeal in the Court of Special Appeals. And if not, review stops in the circuit court. And if you try to seek further review in the appellate courts, the appellate court can grant a motion to dismiss the appeal for lack of jurisdiction. So as John said, again, biggest takeaway from this part of the presentation is be sure to carefully research whatever statute your case is brought under to make sure to avoid any pitfalls here. You can also seek review in the appellate courts of administrative mandamus petitions if you're unhappy with the outcome in circuit court. And you can also seek review in the appellate courts of a review action in the circuit court that invoked the circuit court's original jurisdiction. So that's a mandamus action, a declaratory judgment action. Those really apply in quasi-legislative cases, and we'll talk more about those in a minute. John, could you go to the next one? Thank you. So at the outset of a case in Maryland, if you're seeking review of an agency decision, a very important question that will determine both the procedure and the standard of review is what capacity was the agency acting in when it made its decision? Was it quasi-legislative or quasi-judicial? And this is not as clear as it is in federal administrative law. Much ink has been spilled by Maryland practitioners and judges on this question, and yet, as Judge Wilner observed in the Board of Public Works versus Hovnanian case, a case that I'm sure is quite familiar to the folks in this section, there is not a precise line of demarcation between quasi-legislative and quasi-judicial actions. And in fact, in that case, the court even took the step of saying explicitly that the agency decision had aspects of both. But typically it is one or the other, and these terms are not defined in state statute except in the Open Meetings Act. And so you see those Open Meetings Act definitions up here in this slide. They have been cited by the courts in cases outside of the open meetings context, so we thought that they would be at least persuasive here. The basic distinction between the two, as John already mentioned, is pretty easy. At core, quasi-legislative actions are regulations, rules, policies, decisions that have the force of law. At the quasi-judicial, a decision is a contested case. It's a hearing before an administrative agency or an ALJ in which there is fact-finding or conclusions of law, usually dealing with a license, dealing with some fundamental right of the subject. So it's a little tougher, though, to distinguish between quasi-legislative and quasi-judicial decisions when the decision doesn't fall neatly into one of those two buckets, either rulemaking, regulation, or contested case. And so those kinds of cases, these harder to distinguish cases, typically come up in the land use context, when the decision under review is a decision by a local zoning authority or a county council, for example, about how to classify a particular property. And here we have some language on this slide from that Hovnanian case that tries to draw that line. And so the question the court's trying to answer in these tougher to distinguish cases is, what was the basis for the decision? Was it made on individual grounds, making it more likely quasi-judicial, or was it made on general grounds, making it more likely quasi-legislative? So, for example, more general grounds in the land use context would be, how does the classification of this property fit with the county's plan for long-range development? But more individual grounds would be, well, what actually is happening on this property? What are the people who own it doing? What are their activities on the property? If that's what's determining the outcome, then it's more likely quasi-judicial. And if you think that this is not 100% clear, you are not alone. The main point, though, is if your case is not in those clearly defined categories, either regulation or contested case under the APA, you should do some research into whether the type of decision that you're challenging has been characterized by the courts as quasi-judicial or quasi-legislative. We can go to the next one, John. Thank you. And so why does that distinction matter? It matters because it affects the form of your request for review. Under the APA, if you are seeking review of a contested case, you file a petition for judicial review, and you follow the provisions of Maryland Rule 7202, for the form of that petition. If you're seeking judicial review of a quasi-judicial decision that's not under the APA, or under any statute for which there is no explicit statutory review, then you use an administrative mandamus petition. And that actually follows the same form as the petition for judicial review under 7202. It's just styled differently. But if you are seeking judicial review of a quasi-legislative action, it's a different action altogether. If you're trying to challenge the validity of a regulation, you're filing a declaratory judgment action. And that's provided for in the APA section on regulations at State Government 10125. Now, if you're seeking, however, judicial review of a quasi-legislative decision in one of these harder to distinguish cases, like the land use cases I was just talking about, then you have to invoke the original jurisdiction of the circuit court. And in the Bethel World case that's cited here, they lay out the options for what you could do: common law mandamus, injunction, declaratory action, certiorari. In Bethel, the plaintiff invoked all of them, and in fact, the plaintiff even included a count titled, quote-unquote, judicial review. So it's not clear, as you see in this citation to Talbot County here, it's not clear that common law mandamus is still available if what you're trying to do is challenge an agency decision that is quasi-legislative, but the others are still good. Be careful, though. An action is subject to dismissal if you choose the wrong vehicle. So what I mean here, just to give an example, there have been cases in which the Court of Special Appeals has affirmed dismissal where the petitioner filed a petition for administrative mandamus seeking review of a quasi-legislative decision. And then the circuit court dismissed, holding that the agency's decision was legislative and so therefore not subject to challenge by administrative mandamus, and the Court of Appeals agreed and affirmed. So because that petitioner chose the wrong vehicle, they didn't ever get to the merits in that case. So again, be careful, do your research, and consider if you're in one of these sort of tricky in-between cases, maybe cover your bases and seek review under multiple avenues just to be safe. We can go to the next slide. All right, so in a quasi-judicial action, this is going to look very similar to the slide that John had up before about federal courts. When you're challenging a quasi-judicial decision in Maryland, whether it's a contested case under the APA or an administrative mandamus action, the court can reverse or modify the decision if it was unconstitutional, if it exceeded the agency's statutory authority or jurisdiction, if it resulted from an unlawful procedure, if it was affected by any other error of law, if it was unsupported by competent material and substantial evidence in light of the entire record as a whole, or if it was arbitrary and capricious. There's an additional ground that's specific to employment cases that we note here on the slide. And essentially this boils down to three grounds: either legal error, substantive or procedural, or lack of substantial evidence, or arbitrary and capricious. Note that abuse of discretion, interestingly, is only a ground for reversal in administrative mandamus cases, not when you're challenging a contested case under the APA. Is that a meaningful additional ground for review for administrative mandamus petitioners? It's not clear. That hasn't been well explored in the case law. And in fact, it is something that petitioners should consider if they're challenging a decision under administrative mandamus. All right, and now last but not least, standards of review for quasi-legislative action. Here, the bases for modifying or reversing an administrative decision are far more limited. If you're challenging a regulation, the APA provides the standard. The court shall declare a provision of a regulation invalid if the court finds that it's unconstitutional under either the federal or Maryland Constitution, if it exceeds the agency's statutory authority, or if the agency failed to comply with statutory requirements for adopting the provision. So in other words, if it's unconstitutional, if it's not consistent with statute, or if it was adopted without the proper procedure. For other types of quasi-legislative decisions, again, these sort of tricky in-between ones we talked about, like land use decisions we discussed, the court asks just fundamentally whether the agency was acting within the scope of its statutory authority. The Court of Appeals has described this as an even more limited standard than arbitrary and capricious review. So if you're representing an agency in defense of a decision, this standard is great for you. If you're challenging the decision, not so much. So here's where John's point comes in about trying to figure out what standard is better for you. If your case is one of those in which it's not 100% clear whether the decision was quasi-legislative or quasi-judicial, you may consider trying to make the argument that it is one or the other depending on which standard is better for your position. Of course, as long as you can make that argument with a straight face. If you can't, I defer to the judges on our panel and say you shouldn't even attempt it. So that brings us to the conclusion of this first part of our presentation about initiating judicial review.
Great. So if Megan and I haven't given you enough to worry about, next we're going to hear from Judge Leahy, who's going to talk about the exhaustion requirements. And I should also note that we're very pleased to be joined also by Judge Leahy's law clerk, Jack Karpinski, and they're going to walk us through the interesting world of administrative exhaustion.
Can you hear me now? Can you hear me? Okay, good. Good morning, everyone. I want to thank you for introducing Jack, my law clerk. He's going to be running the slideshow because he created the slideshow. I asked Jack, who's working with me on a paper on administrative exhaustion, to create a slideshow and try to make it fun, which is a really tall order for administrative law, right? But I think he did a pretty good job. And it's possible. I remember many years ago working with Judge Fader, who I see is on here, and Michelle McDonald, and we had a lot of fun in these presentations. So I hope this at least meets that relatively low bar. So let me start by talking about the rationale for administrative exhaustion doctrine. And that was articulated, I think, very well back in 1976 in a case that was authored by Judge Levine in Soley versus State Commission on Human Relations. And he pointed out how, you know, the decisions of an administrative agency are often very discretionary in nature. They're often highly technical. They require agency's expertise. You all understand this. And so we want to give the agency every opportunity to exercise their discretion. And that we try, at least under Maryland law, to not to permit interruption of the agency process, because that would undermine the very efficiency that the legislature had intended. And also, by letting the administrative agency ferret out all of the issues, that what ends up happening, we hope, is that the issues are more focused and discrete by the time they get to the place where they can be reviewed by the circuit courts. So the doctrine of administrative exhaustion really protects the primary and exclusive jurisdiction of the agency by assuring that the agency has the opportunity to resolve the issues. And it's very much intertwined, when you think about it, with the doctrine of separation of powers. So first step, as you know, John and Megan pointed out, is, where are we? Are we talking about Maryland or federal administrative law? And as John and Megan pointed out already very well, there are a number of differences between the two. So at the federal level, there's a presumption that exhaustion is non-jurisdictional unless Congress states in very clear and unequivocal terms that the judiciary is barred from hearing an action until the administrative agency has come to a final decision. That principle was just very recently underscored in United States versus Muhammad, the Fourth Circuit case in 2021. There, the court said, only if the statutory text plainly shows that Congress imbued a procedural bar with jurisdictional consequences should a court treat a rule as jurisdictional. Now, to the contrary, in Maryland, exhaustion is a threshold issue, and it is treated as it's jurisdictional in nature. So Judge Eldridge really underscored this principle in Renaissance Centro versus Broida case, and he instructed that courts must address the related issues of primary jurisdiction and exhaustion of administrative remedies, regardless of whether they're raised by the parties. So in Maryland, administrative exhaustion is treated as a jurisdictional issue, but then allows for certain exceptions, which we'll discuss later. Conversely, under federal law, which defaults of the non-jurisdictional, when Congress does identify an administrative regulation exhaustion requirement as jurisdictional, then, unlike in Maryland, the exceptions don't really apply. Now, as Megan and John pointed out, another distinction between the federal and administrative law is that the federal courts are of limited jurisdiction. So you have to, look at the statute to find your way into court. And of course, the corollary to this presumption is that the Congress can provide that the agency has no judicial review, and that was, that's expressed in the federal APA. I just want to point out that in, as an underscore in Maryland, the courts have established that Maryland courts have this inherent power to correct abuses of discretion and or arbitrary capricious acts of administrative agencies by mandamus actions. And very recently, the Court of Appeals underscored this in Marin City Council of Baltimore versus Proven Management 472 Maryland 642. But in that case, again, we have to separate, the power of judicial review and the right to appeal. The court in Proven, citing and relying very much on an older case, Criminal Injuries Compensation Board versus Gould. Most of you in this section know that case very well. Underscored the principle that the right to an appeal is not required by due process, nor is it inherent inalienable right. And in Proven, relying on Courts and Judicial Proceedings 12302A, the court said there was no right to appeal in Court of Special Appeals, because in that case, Baltimore City Charter did not provide that. So, okay, so the rest of my discussion is just going to be divided into these three sections. Hold on one second. All right, make sure I'm on the same screen with all of you. All right. Okay, so the exhaustion requirement stems from three sources. Most often, the exhaustion requirement is found in the statute, but sometimes they can be judicially created or agency created. If so, you want to now, as I'm not going to go into the APA very much, Maryland APA. I think John and Megan covered that, but obviously we have the APA. You need to look at the agency's organic statute, however, define the scope of the agency's, particular subject matter, the authority over that subject matter, the authority to promulgate rules and regulations, and you need to find out what the process is for obtaining a final decision. Now, for the federal question, again, you look at, there are three interpretations generally under federal law. Jurisdiction, exhaustion requirements that are jurisdictional, and as I just pointed out, that has to be very specific mandate. Then there are mandatory claims processing rules, and then there's the completely non-jurisdictional administrative exhaustion requirements. And under federal law, whether a statute is intended to preclude initial judicial review is determined from the language, the structure, and the purpose of the statute. And the courts look to what are called the Thunder Basin factors to decide that. It's the case is cited here on the slide, Thunder Basin Cole versus Reich. I want to just point out that very recently the Supreme Court evaluated a statutory exhaustion requirement in United States versus Palomar Santiago. That's 1-for-1 Supreme Court 1615/2021. Judge Sotomayor wrote the opinion for the majority of the court. And in that case, Mr. Palomar was charged with illegal re-entry in the United States under 8 U.S.C. 1326A. When he challenged that conviction, he challenged his 1998 removal order because a subsequent law had rendered his DUI conviction, for which he was originally deported, to be not an aggravated felony. So there was a split in the circuits as to whether you could excuse exhaustion where the conviction was no longer one that would qualify as a deportable conviction. However, Justice Sotomayor in the Supreme Court, looking at Section 1326D of the law, said that Congress had provided the defendant may not bring a collateral attack on the underlying removal order unless and until they had exhausted all administrative remedies that were available. So unfortunately for Mr. Palomar Santiago, because he did not exhaust his administrative remedies at his deportation hearing, he could not thereafter challenge it. So now, where the General Assembly has provided either an exclusive or primary administrative remedy and a judicial review remedy, the declaratory judgment action brought outside that remedial scheme is prohibited by the Declaratory Judgment Act found in 3409B. But the DEC statute does recognize that exhaustion of administrative remedies is not required where the agency's jurisdiction is concurrent with the courts. A good example of that was Maryland National Park and Planning Commission versus Washington National Arena. And that's a case where the court decided that the circuit court could address a tax case, an issue in a lease agreement that was a tax question, because the nature of that question was one that either the tax court or the circuit court had power to declare. So again, you got to make sure you understand whether you're dealing with an APA agency, not the American Pool Association, which is what we came up with when we did our search for APA on the web. So the APA statute provides that a party who is aggrieved by a final decision in a contested case is entitled to judicial review. Again, you need to look at the organic statute of the agency to find out what the procedure, what the process is to bring you to a final decision. And that varies greatly. For those of you, for example, who have practiced before the Maryland Board of Contract Appeals, you know that they have very different and short deadlines for contesting or challenging procurements and bids. So I think John and Meghan already made this point, but I would just underscore it. You just really, really have to study and understand the agency's organic statutes in these cases. But for, sometimes, I mean, that's easy to do when you're talking, easier, I should say, to do when you're talking about an agency like MDE and DNR. But when you're talking about a smaller agency that's created, or a more temporary agency, like let's say the Natalie Parad Cannabis Commission, and you're trying to figure out, what their rulemaking authority is and what the administrative procedure is or process for exhaustion, that can get a little bit more tricky. So just wanted to point that out. It can be tricky sometimes, especially with some of the more temporary agencies or offices that are created by the General Assembly. Let's see. So, and of course, as we mentioned, the exhaustion requirements can be agency created, and in Maryland, they're contained in numerous regulatory frameworks. I mentioned before that procurement regulations, they're found in COMAR primarily. And also sometimes agencies can provide right in their statute that you don't need to exhaust administrative remedies. And there's, for example, I found this, actually I should say Jack found this statute in DNR COMAR regulations that said you don't need to exhaust the administrative remedy provided under Section A before filing a suit related to the Public Information Act. So now, judicially created. Maryland courts have favored an agency first rule. Promotes judicial efficiency, protects the agency's discretion, as I mentioned before. Federal law is a little different here. Remember before I said that Maryland doesn't, well, I should point out, Maryland doesn't really distinguish between APA and non-APA agencies in applying the principles of exhaustion, but the federal courts do. And I think that John and Meghan had pointed that out pretty well. So I'm going to just go to the next slide since they mentioned that. But going back to Maryland law, I want to just do a little sidebar because intertwined but separate from the doctrine of administrative exhaustion is the concept of primary jurisdiction. And primary jurisdiction is a question that enters when a claim is initially cognizable in the courts, but it raises issues or relates to subject matter falling within the special expertise of an administrative agency. So for example, if a court concludes that it has jurisdiction over a dispute, but that an issue raised in the dispute is within the primary jurisdiction of the agency, the court may defer the decision in the dispute back to the agency before it addresses the issue. The leading case, I'll just say quickly, on primary jurisdiction in Maryland is Zappone versus Liberty Life Insurance Company. All of you in the administrative law section, I'm sure are very familiar with this case, where Judge Eldred instructed when the distinctions between exclusive primary jurisdiction and fully concurrent. In Maryland, there's no presumption that an administrative remedy is exclusive where there is an alternative judicial remedy under another statute or under common law or equitable principles. Instead, in Maryland, there's a very strong presumption that any administrative remedy is intended to be primary. And Sapone, again, set out the factors that should be considered in determining whether the presumption of a primary jurisdiction should be rebutted. So next we get to the exhaustion exam. And we'll start with ripeness. Okay, in general, ripeness depends on fitness of the issues for judicial decision and the hardship to the parties of withholding court consideration. A ripe action is obviously one that is final and is not dependent on future uncertainties. In the administrative context, Judge Hollander pointed out in the Standage opinion case that we have cited there, that the doctrine of ripeness prevents the courts from entangling themselves in abstract disagreements over administrative policies. Finality. So matters of finality often converge with the exhaustion doctrine. Most apparently and obviously where there is no finality because the litigant failed to take the steps to reach a final decision. Nevertheless, the doctrines of finality and exhaustion are distinct. Exhaustion requires a grievant to invoke and pursue the administrative process until he or she receives a final decision from the agency at the utmost level of the administrative hierarchy. That is, of course, if there's in the absence of an interlocutory appeal that's permitted. Finality, on the other hand, refers to the quality of the decision by the agency at the top of the hierarchy. So to be final, the order or decision must dispose of the case by deciding all questions of law, in fact, and leave nothing further for the administrative body to decide. For an example, an administrative order that determines liability but does not decide damages is not final. The Priester case, which we decided up at the, I think one of the front slides is an example of this. In that case, Mr. Priester challenged his termination under the Baltimore County Code, and he was a firefighter, and there were some additional union requirements for exhaustion. He followed them all the way up to the final board, which then they tied in, so they couldn't reach a decision as to whether his termination was proper or not. And then they had indicated that they would meet again once they could get another commissioner replaced. Well, Mr. Priester filed a mandamus action, and he wanted the court to order that the decision, the deadlock decision, was a final order of that board. And then, of course, he had a theory, a legal theory that went along with that, and said that the deadlock decision equated to a determination that his termination was improper. We held that he did not have a final administrative decision, so he had not exhausted his administrative remedies. And this is why I mentioned the distinction between exhaustion and finality is in the quality of the final decision. Then we go to issue preclusion. Again, issue preclusion overlaps with finality, but it's important, I want to point out, not to confuse issue exhaustion with the exhaustion of administrative remedies, because especially at the federal level, there are some different laws that treat these distinctions. And that timer said that, you know, I have gone 20 minutes, so I'm going to go through the rest of these slides very, very quickly. To the extent that I don't get to everything, you'll see the important cases to look at in the slides. I think you'll see everything you need to know there. So I'm going to go quickly to the exceptions. Okay, so we have in Prince George's County versus Bloomberg, the Court of Appeals first examined all of the cases and collected what were originally expressed as 5 exceptions to the doctrine of exhaustion. Over the years, the Court of Appeals eliminated 1 exception, combined 2 exceptions into 1, and pared each down the remaining exceptions down in their scope, and thereby displaying a very strong preference for primary jurisdiction and administrative exhaustion in Maryland. Now, if you look, we now have really essentially only 3 exceptions. The one that is blank is, there it is, inadequate or unauthorized procedure. Right shortly after Bloomberg, that exception was disavowed in a couple decisions, but sort of in dicta. And then finally, in the Hovnanian case, for those of you, well, that was mentioned in the first presentation, in the Hovnanian case, Judge Glenn Harrell basically, put the death knell on the unauthorized procedure as an exception. The constitutional exception has been repeated in many Maryland appellate decisions. The view in Maryland is that administrative agencies are fully competent to resolve issues of constitutionality, including the constitutionality of an enactment as applied, as well as the constitutionality of an enactment as whole. However, notwithstanding this competency, Maryland case law has recognized a very narrow constitutional attack when the challenge is to the constitutionality of the statute as a whole. However, I want to also point out that in a case that United Insurance versus Maryland Insurance Administration 450 Maryland 1, 2016, the Court of Appeals pointed out that in that case, somebody challenged the retroactive application of a new statute and regulation under the MIA. The court said they didn't challenge the whole statute, just the retroactivity component of the statute, and therefore it did not qualify in this very narrow exception, the constitutional exception. Sometimes the constitutional exception can be applied when someone is attacking the agency's jurisdiction entirely, but that's also very rare. The next exception, inadequate remedy. So that is also very rarely, there are very few cases that we have. In fact, I would say there's probably, it's going to be very hard to prove that there is an inadequate remedy. I think the only one, that recent case after Heaney was the state center case, in which Judge Harrell said there was an inadequate remedy under the state procurement regulations for these citizens to challenge a state procurement. That's obvious because obviously taxpayers are not either the agency or the bidders. But there really hasn't been another case since state center that has authorized this exception to the doctrine of exhaustion. And I am going to just, the next slide quickly is no agency jurisdiction. That's what we just talked about. I think it's going to be very hard. I just mentioned to find that an exception under, because I mean, the philosophy is that the agency should first make a pronouncement about whether they believe they have jurisdiction over a particular case. And then the courts will determine whether that their reasoning or their review of the statutes that they've either regulations they promulgated or the statutes that govern them make sense and whether they really do have jurisdiction or not. So we very rarely see the no agency jurisdiction exception applied. So I tried to rush at the very end because I was at the end of my time. I don't know if you're exhausted, but I am, so I'm going to stop.
Thank you so much, Judge Leahy and Jack. We are now going to turn to Shiva Goel, who's going to talk about making a good record in the agency to set yourself up for review. And I will be running the slides. So in just a moment, I'll get my screen share going.
So thanks, John. Thanks, Judge Leahy, which was a great prelude into this next section, how to prepare the record for appeal. I know it sounds a bit dry, but it's actually one of my favorite parts of agency practice. My practice tends to focus on rulemaking proceedings before federal agencies, and most typically the FCC, the Federal Communications Commission. So that's the context I'm coming from, and that's where I'm going to focus here. Informal rulemakings under the Federal Administrative Procedure Act, which is the source, I think, of most appeals for federal agencies that find their policy decisions being challenged in court. And the focus also will be more on day-to-day practice to give you a glimpse into what practice looks like at some agencies and how they do business. I'm not much one for slides. If I mention a case and you want to know more about it at our site, please feel free to loop back up with me after, and I'd be happy to get you a little more information. But why don't we start by situating ourselves in a complex rulemaking proceeding before a federal agency. Let's say we are representing a car maker or a software company before an agency tasked with road safety, like the Department of Transportation. We're knee deep in the issues, and we're fighting on behalf of our client, tooth and nail, against a proposed rule that would require cars with self-driving technology to complete a total of 50 million automated test miles on public roads before they can push an update to the self-driving software and have that update hit vehicles in the marketplace. And the agency is doing this in response to a string of well-publicized accidents involving this technology, and there's an outcry that something be done. So you've been participating in the rulemaking, and your audience so far has been policy staff, maybe some politicos, certainly some engineers, many with a JD, and certainly all with a high level of experience and fluency with the issues, but they're not the agency's litigators. And in fact, I think in at least many cases, the folks who will be defending an agency at court may not be very involved in the process of promulgating new rules. And heck, they might not even be at the same agency. In many cases in the federal system, the lawyers of the Department of Justice are going to be spearheading post-decision litigation rather than attorneys in-house. So the point here is, while you've been arguing the issue on the merits, hey, this rule is going to hurt innovation. You're going to make it worse for consumers. We won't be able to push these updates out, and they're going to be less safe. That's all well and good, but if you find yourself losing, or if you're at least not sure you have it in the bag, and your client turns to you and says, "This rule is crazy. If it gets adopted, we'll see them in court." It's time to start looking at things a little differently in terms of what you're saying to the agency and what you're filing before the agency and how you're making the record. The first concern is the requirement of issue exhaustion, which Judge Leahy spoke about as part of her exhaustion exam. And as she said, you need to raise any issue or argument that you think you might want to raise on appeal before the agency. If the agency didn't have an opportunity to pass on the argument, the reviewing court isn't going to do it in the first instance, absent some extraordinary exception. And so we're really talking about preservation. This is different from remedy exhaustion. The issue isn't that you had further recourse at the agency when you lost and you must exhaust those remedies first before getting a final order. It's that no part of the agency at any level had a chance to rule on what you're raising. So the practice point becomes, how well do you have to do this? And this is a decision point that practitioners go through all the time. And what I want to sort of impress on folks here is that there are often good reasons to resist the lawyerly temptation to want to hide the ball. Many of us, when something gets adversarial and tense, and when we're required kind of early on to state a position, we want to do the bare minimum, and that often makes sense. And certainly in trial practice, sometimes a short and plain statement about your objection and the grounds for it will suffice. And if that's your inclination, there is certainly law that says you don't need to preserve issues in, quote, precise legal terms. And frankly, the standard for how well you have to do it, how specifically you have to do it, is pretty mushy. But again, there are reasons why you might want to say more rather than say less. First, the obvious point is we are talking about a threshold issue that will determine whether you can even press your case in court. It's not necessarily the best time to futz around and toe the line of a standard that, again, is mushy. Second, the fundamental goal of issue exhaustion is not just to put the agency on notice about your position. It's really to give them a meaningful opportunity to consider what you're saying and rule on it in a thoughtful way in their decision. And there's law in that too. So if you're just giving them some breadcrumbs, the agency is going to have at least a non-trivial argument that the standard wasn't met. There are admonishments from courts, including the Supreme Court in Vermont Yankee, where they're cautioning challengers against making, quote, cryptic and obscure references before the agency, and then sandbagging the agency with the real substance once they get to court. That has an unfair surprise flavor to it, and is something you probably want to avoid. There are more reasons. Often, the less you say, the easier it is for an agency under a deferential standard of review to persuade a court that it has addressed your issue adequately. And sometimes it might not need to do much more than acknowledge that the issue was raised. So coming back to our road safety example, if you say this 50 million mile testing regulation will stifle innovation, and you talk about how important you are, how much you contribute to GDP, how important you are in the international race for economic competitiveness for AI and other things, and that arguments that do have appeal to agency decision makers. But if you leave it at that, an agency, the lawyers that are actually putting together the agency's order could kind of similarly wave their hands and say, we've considered this issue, and using our predictive judgment, which is entitled to significant deference in areas of our expertise, and balancing all competing considerations, our rule is reasonable. That literally could be enough for them to prevail in court on that issue. On the other hand, if you cite a study saying that for most developers of this software, meeting the requirement will take 2 to 3 years, while they're creating updates every 6 to 8 months, and in that intervening period, more people are going to get hurt. That type of specificity is going to put the onus back on the agency to not just, throw the position into a generic balancing, but to deal with and wrestle with the evidence and the specifics if it wants to get a court to really think that deference is wise here. And finally, maybe you're pushing yourself to think about the appeal. maybe if you're if you're doing that, you might end up filing stuff before the agency that's going to help you persuade the agency too. Persuading the agency is often much better than suing the agency. You've got the standard of review. The odds are stacked against you as a petitioner in a lot of these cases. And then, even if you win, you might prolong the battle, but depending on the scope of remand, the agency could, explain itself better and adopt the same rule. And you're sort of back to square one. You could find yourself with a remand without vacatur, which is, I guess, the administrative equivalent to basically a verdict on liability and zero damages. These are all reasons why your first priority should be to win at the agency to the extent you're possible, and not to try to game the system to give you some edge in litigation by not being clear about what your position actually is. So back to our example, maybe you could get, if you make a compelling case that what they're doing is unlawful, maybe you could get them to go down from 50 million miles to 25 million miles, or create an exception that's advantageous to your clients, or something like that. But the point is to try to use your advocacy in contemplation of the appeal in a way that's also aligned with your primary goal of convincing the agency to do something different. So you want to say more rather than less. What can you do tactically to mitigate the risk that comes with being really specific and filing what can sometimes be a draft of your appellate brief before the agency, the FCC, in what I do, even reaches a decision? Well, you can file it at the last minute, not the 11th hour, maybe not the 10th, but the 9th hour. In fact, at the FCC, there is a practice that periodically goes out of favor, but seems to have regained traction recently, where the week or two before an order is scheduled for a vote by all the commissioners, parties who feel like they're losing will file an ex parte letter setting forth the arguments they plan to raise on appeal, and they'll do it about a week before the order is adopted. And this practice is very irritating for all lawyers involved. For the lawyers doing the work, we lawyers hate being rushed, but you are not only putting together your potential appellate argument in a 2-week time period, you are also contending with what everyone else is filing in that 2-week time period, and it's not necessarily a lot of fun, but it takes care of your preservation issues pretty well. And then the lawyers at the agency have practically no time at all to try to make sure they've revised their order to address all of your arguments, even some of the bad ones. But I think all sides would agree that that sort of practice is better than being totally surprised in court. And so there has been a degree of acceptance of this type of practice, at some agencies and at the courts, who so far, haven't sort of said, hey, you're not giving the agency enough time here to consider your views. So another matter somewhat related to issue exhaustion is that for some agencies, and some circuits at least, you may actually need to be a party that participates in the proceeding before the agency in order to have a right to appeal, even if your interests are very obviously affected by what the agency has done. So the Hobbs Act, which John, I think, had mentioned, it only permits a, quote, party aggrieved to sue. And courts have said, to be a party aggrieved, you need to have direct participation. And this goes to basically your statutory standing to file an appeal. When an agency's organic statute has other provisions, which is the case with the FCC and the Communications Act, there might be a more lenient standard. The Communications Act, for example, permits any quote unquote person aggrieved to sue. And some courts have said you can be a non-party and sue so long as you're raising claims that someone in the proceeding raised and you're not surprising the agency on appeal. But Not all situations are like that, and it's usually best to be a party. Otherwise, you might find yourself with your appeal dismissed, or you might find yourself having to petition the agency for reconsideration so that you become a party, waiting for the agency to deny your petition, which you know they will do in many of these instances, and then appealing the denial. And over the years where this procedure is playing out, you're going to have to comply with the rule that you dislike all the while, unless you get a stay or some other type of extraordinary relief. So extra points, that last bullet on this slide. There's more you can do to prepare the record as a petitioner than merely preserving your potential appellate arguments. You can also create new ones by supplementing the record in a strategic way. And so if we think about what an agency appeal looks like, there are basically three types of arguments parties raise in a pre-enforcement challenge. And that is the order is facially unconstitutional or lacks statutory authority. There's no legal basis to adopt the order in the first place. It was procedurally invalid, insufficient notice and comment, for example. And then category 3 is it was the product of unreasoned decision making, due basically to poor judgment or a lack of evidentiary support. And courts have equated reasoned decision making with decisions that are not arbitrary and capricious under the Administrative Procedure Act, and thus can withstand judicial review. And if we focus on that third bucket about reasoned decision making, the availability and the strength of your arguments are going to depend very strongly on what the record looked like before the agency, and you can use that to your advantage. So, if maybe we should briefly talk about what decision-making errors have been recognized by the courts. If an agency departs from its prior precedent without rationally explaining itself and accounting for reliance interests, that's unreasoned decision-making. If an agency fails to consider a point made on the record, a material point, that's another ground for vacating an order for unreasoned decision-making. And these are useful, but an agency can often say, and this will sound familiar, we acknowledge that party A made this point in the record, and doing our careful balancing, we've come out a different way. And that again, that conclusion might stick. One way to make it harder for that type of rely on my expertise and defer to my expertise and my careful balancing. One way to make that harder to stick is by proposing an alternative that meets the agency's stated goal, but is just better all around for everybody, or at least, one could argue that it is. And the best example of this is from the landmark case on reasoned decision-making in Motor Vehicle Manufacturers Association versus State Farm. The agency in that case was the Reagan-era Department of Transportation. It rescinded a rule requiring detachable automatic seatbelts and airbags in cars. Those requirements had been imposed in response to widespread noncompliance with, messaging saying put on your seatbelt. And the agency's principal rationale was, look, people are going to detach these seatbelts anyway. What's the point of the requirement? And so some challengers said, well, why don't you just require the use of automatic seatbelts that aren't detachable? And also, what does that issue have to do with airbags? Couldn't you just require airbags instead? Wouldn't that address your concerns? And the court vacated the agency's decision because the department had not adequately addressed those alternatives. It didn't say the agency has to adopt those alternatives, but it sent the case back. And that's a win. And now remember, this was in the early 1980s. The agency politically likely had a strong deregulatory bend to it. And it's possible, indeed very likely, that any mandate at all wasn't going to be entertained by agency leadership. But just because the alternative wasn't likely to persuade the agency doesn't mean it wouldn't be a useful tool in court. And so when you're thinking about preparing the record for appeal, think about reasonable alternatives, even if you're skeptical that they're going to change someone's mind at the agency. John, maybe we could switch to the next slide. And now I kind of want to talk briefly about the mirror image of this. You don't have to be losing at an agency to want to supplement the record in contemplation of an appeal. When you get a decision out of an agency that you like, at least before some agencies, there's a strong practice of going to court and intervening in support of that agency on appeal. As an intervener, you might get to raise arguments the agency didn't feel comfortable raising or didn't want to waste words raising. Perhaps some long shots on standing or other threshold issues that you think you might have a chance to win. You might speak with more credibility about the benefits of the order that you're trying to defend. And you can also help clean things up at argument if you're able to split time with the agency. But before all of that happens, you can also do things just to make the order better. And that's important because under SEC v. Chenery, that's a Supreme Court case from the 1940s, agencies are subject to their own type of issue exhaustion requirement. And that is an agency's grounds for defending its decision as reasonable in court, as lawful in court. Those grounds must be articulated in the decision on review itself. An agency's unappointed appellate lawyers can't make up reasons that are better during litigation. And so this means that the decision that you and your client have fought tooth and nail to win better be well reasoned. So what can you do? Well, you can help the agency make sure it has a factual basis for what it's about to do. In many cases, the applicable standard is the substantial evidence standard. And this is one of those examples where the legal meaning of the word has almost nothing to do with the English meaning of the word. Substantial evidence tends to mean more than a scintilla, but less than a preponderance. Anything a reasonable mind might accept is enough. There are additional caveats that say, if the evidence is subject to interpretation in two ways or multiple ways, the agency's judgment should not be second guessed. So it's not a terribly high bar, and yet some agencies still flunk it. And that often happens when the agency needs support to sort of respond to evidence that others have submitted, because courts will apply the substantial evidence standard looking at the record as a whole, and won't sort of allow an agency to cherry pick, preferential studies. So, if you have someone on the record who's opposing the rule, saying, we've provided evidence of our own and it shows that this rule is not a good rule and nothing in the record shows the contrary, the agency decision cannot stand. That's the type of area where, as a supporting party, you want to be helping the agency fill that gap. If we want to take it back to our example, let's say you love this 50 million mile testing rule. You're a public safety oriented organization. In response to the manufacturer's claims about self-driving cars being better than human drivers and posing no incremental safety risk, you might want to put in something saying the software is not mature. In its current form, it's going to miss these corner cases where a human driver might actually prevent an accident. And new software versions are inherently risky when you consider just how much work went in to put the initial version out there. Maybe a similar amount of diligence should be done before we push an update. And maybe you're a large insurer, and that's why you like safe roads. And maybe you have data on claims that you're paying out or claims that are getting filed. And you can sort of slice and dice them between self-driving cars and normal cars and provide something useful. Give the agency a leg to stand on. And so I'll tell you, and I'll close with this, what a common practice for FCC folks is. The FCC has a process where 3 weeks before the vote, it'll release the white copy of big decisions. You'll get to see the draft. Everyone will get to see the draft. If you like what you see, but you know there's going to be a challenge, it's almost expected that you will participate in the proceeding for those couple of weeks before the vote, even though you've basically won. What people do is they review the draft text carefully. They help point out issues. They even meet with staff and the Office of General Counsel to try to make the order, the final version of the order, appellate proof. If you find an opposing argument or a study or a tangential issue that an opponent had filed, but just got lost in the mix, which by the way happens all the time. When you look at these, you're talking about tens of thousands, just ginormous, gigantic agency records in some of these complex cases. Elevate that issue, make sure the agency doesn't miss it in the last stretch, and offer up, a reason why that shouldn't change their mind. If you see the agency relying on evidence that hasn't been formally incorporated into the record or made public, let them know, and maybe they go through that process before they adopt the order, because there are certainly DC circuits cases that say an agency can't do that. Be on the lookout for the preservation letter that challengers might file, and give the agency a way to respond to each point, so they aren't Cheneried on appeal. And remember, agencies are busy; they're working on 20 things at once, and the records have grown extraordinarily large in the modern age. And there's no use sitting on your laurels just because you know that the agency is kind of aligned with your client's way of thinking. I'll wrap it up there.
Great, thank you, Shiva. The last segment of our presentation is going to be about administrative appeals in courts, particularly in trial courts. And so for that, we're going to turn to Judge Cox. And we've also invited Judge Leahy to offer any commentary she might have from her perspective as an appellate judge as well. But I will now hand it over to Judge Cox.
All right. I think there was, as I'm trying to figure out my technology, I think there was one question in the chat. Maybe if we look at that. As I start into this, I will tell you that as I was preparing for this today, I was looking at PowerPoint, and there's a new provision I've never seen in the PowerPoint online sort of suite of things that allows you to practice your PowerPoint. So I was curious to see what it does. It actually critiques how you speak. It gives you comments on how fast you speak. And apparently I use the word more times than any person in their right mind should. So I'm apologizing for that in advance and hoping my technology works for you. In looking at this issue and in addressing this panel presentation as a whole, I feel like my role in this is sort of representative of my message. You need to know your audience when you come into a trial court to review an agency decision. Particularly, and my perspective on this is Maryland state trial courts. Administrative agency review is not something that is frequently seen in the trial courts. I know this from the state court perspective, and looking at some data, I think this is also true in the federal court perspective, with limited areas which get the volume of appeals. And for practitioners like Shiva who practice in this agency in the federal arena, there are limited jurisdictions that they're appearing in that have developed an expertise. For the bulk of people, if you're coming into a trial court, you're going to appear in front of a judge who does not regularly see administrative agency matters. And to drive this point home, I'm kind of geeky on numbers at times, so I pulled some numbers. If you look at the Maryland State Court numbers, the total caseload, look at 2018, 2019, 2020, taking 18 as representative pre-pandemic, there were 231,000 and change cases statewide. Of those, 64,000 and change were civil cases. And out of that number, 2,973 were administrative agency appeals statewide. I'm not going to run through these numbers, but I'll just flash them up there and you can look at them. In small jurisdictions, I mean, you get some counties that'll get 6 in a year. The medium-sized counties, there's some funny outliers that seem to get a little more proportionately, but the numbers are just tremendously low. And within those numbers, I think it's important to recognize those include workers' compensation appeals, which, while they're categorized as administrative agency appeals, in my way of thinking, they're not what we're talking about here today. The vast majority of those are jury trials. I've yet to see one in 20 plus years that actually went on a record like a normal agency appeal. So if you pull those numbers out, for instance, in Baltimore County, last year there were 372 administrative agency appeals in a jurisdiction that has 20 judges. 210 of them were workers' comp. So the numbers that we're dealing with are really, really small. And I think from a practitioner standpoint, you need to think about that consciously when you're figuring out how you present in a state court. The most frequent types of cases that come through state court are motor vehicle administration appeals, unemployment compensation cases that are being filed largely pro se, forced medication cases that are being filed by inmates or by not inmates, I apologize for that, by persons that are in state hospitals, often again unrepresented, and you get occasional inmate reviews. The number of cases that you see from sophisticated practitioners that are reviewing an agency decision are minuscule, absolutely minuscule. I don't have similar numbers from a federal practice standpoint, but I looked at the Maryland district summary of their civil caseload, and it breaks it down in a pie chart of categories. Administrative agency appeals doesn't even make the list in Maryland. And I mean, things get on the list like the Jones Act, RICO, environmental cases, less than 1% of the overall civil caseload. This category isn't even in it. So you need to think about who your audience is. And when you're taking a case up on appeal, you really need to strategize on how you effectively present to that audience without insulting people. The other thing that I think is key, particularly from a state trial court perspective, is to find out if you're appealing in a jurisdiction and you have a complex administrative agency appeal, find out how the cases get assigned. And that's a more complicated thing than you would think it should be. It varies from jurisdiction to jurisdiction. There are very, very few counties, other than single judge counties, there are very few counties that assign all cases from the beginning to a judge, so you know who your audience is. Most counties assign shortly in advance of a hearing. To use my county as an example, in Baltimore County, whether an administrative agency appeal gets pre-assigned to a judge so they know more than a day before it's on their docket that they're going to hear it, that decision is made based on the length of any transcript in the administrative record. Our cutoff is if your transcript is less than 50 pages, it doesn't get pre-assigned. And sometimes you may not have much of a transcript, but you may have an administrative agency record that's complex. That matter may have been assigned as recently as 3:30 on the day before to a judge who's going to hear it. It's good for you to know that going into it because you know what your audience is. It's good for you to know that because you know how better to brief it. So I would encourage you, if you have a complex matter in a state court jurisdiction, to look at the jurisdiction's differentiated case management plan, their DCM plan, to figure out how these matters are being assigned. And in the absence of finding some, real guidance there, contact their clerk's office or contact the administrative judge's chambers to find out whether the cases are going to be pre-assigned. If it's a particularly complex matter that you think requires pre-assignment and you're in a jurisdiction that doesn't do that, I would suggest you write a letter to the administrative judge outlining the complexity and asking if the matter can be pre-assigned for briefing. No judge wants to be unprepared, but sometimes the way assignments are managed in a court, put you in a position where you're getting something that's complex and nuanced without a lot of time to read it and really be prepared before argument. So those are my just sort of practice pointers on that. When you're looking, assuming when you're in state court, and Meghan touched on this, the 7207 really governs what your requirement is in filing a memoranda. It's due 30 days after the notice that the record has been filed is issued by the clerk. And the rule is very specific as to what to be included. And it requires a concise statement of the questions presented, statements of material facts related to each of those, your argument, and citations to authority, and it has a page limit. I note that because there's a tendency when you're filing at a trial court level to file a memoranda that's not structured in the way a brief would tend to be structured in an appellate court. And yet the rule requires presentation that to me parallels what my experiences were on appellate briefing. It's done that way because it eases the review by the judge. You really want a presentation in a memoranda that outlines for you very concisely what it is you're supposed to be focused on, question by question, point by point, with a breakdown of the argument and the citations to the record. And again, looking at your audience, you're dealing with people who are getting these largely as a last minute assignment. So the degree to which you can organize it so that somebody can think through and structure an opinion based on the format and outline that you present is to your advantage. Like, you know, the briefing schedule is 30 days after that you file a response, and that there is a provision in those rules for answering memoranda in another 15 days. The court's required to hold a hearing unless it's waived. In some local courts, it is a good idea when you file your memoranda to specifically in it include a request for a hearing, just like you would in a request for a jury trial, so it isn't some sort of an implied waiver. The disposition options, and Meghan talked about these briefly. I mean, the court has the authority to dismiss, affirm, reverse, modify, which I think is rarely done, or remand, which I think is more frequently done if there's a problem with the decision. And it's because we're supposed to be doing an appellate function. Did the agency get it right or not? And if not, and it needs to be modified in some fashion, in most instances, it needs to go back to the agency for further review and exhaustion at that level. I touched on this briefly already in terms of organizing your memoranda. The thing I would like to do, though, and follow up on Shiva's presentation and talking about the record, frequently the records that come through in state court are pretty concise. But to the extent you have something that is a complex record, when you get a record filed in MDEC, it's really unwieldy for a judge to deal with. You may have citations to a record, but unless you're going to print the whole thing or print portions of it, it's hard to get and manage, and you're doing a review. It's hard to get to the meat of the record that you really want to focus on. I would encourage you, if you have a complex record, to consider filing in addition to the record what is the equivalent of a record extract and done by exhibit, so that you supplement the record with the portions of it that the judge really needs to focus on and consider. So you want the final decision of the agency prominently available to a judge. You want the provisions of the testimony that you're particularly relying on available and accessible, so you're not, electronically plowing through hundreds of pages of things. There's nothing in the rule that requires this. It simply is a courtesy practice pointer that I think is helpful to the judge that's hearing it. One suggestion I would have, if your case is assigned to someone and you have a complex record, contact that judge's chambers and say, is there any problem if I supplement with a written binder, given to the other side in advance, that has the things that I will be relying on in argument. I think the easier you make it for a judge, the better your argument goes. You want somebody focused on the meat of your argument, not fumbling down trying to find the pieces of it that you're relying on. Meghan talked about this, and I'm just going to touch briefly again on the distinctions that in the types of actions that come up. You have quasi-legislative actions or quasi-judicial. The legislative are then again those dealing with the rulemaking and regulation portion of the agency task. Those are really relatively rare in a state court practice. The bigger, and she's covered what the options are in terms of when in that review, what actions can be set aside, unconstitutional, exceeding statutory authority, those issues. The more frequent area of practice, particularly in state court, is determinations and review of quasi-judicial actions, which are those that are more individually based. In that area, this is a very narrow, it is a very narrow review function. The real questions are, is there substantial in the evidence in the record as a whole to support the agency decision? And as Shiva commented on it, it doesn't take much to meet that standard. It is an incredibly deferential standard. Or is whether the agency's actions is premised on an erroneous application of law. And I'm going to kick it to Judge Leahy for a second to talk about the deference that you give to the agency's review on the legal issues, because I think you recently authored an opinion that touches on this standard.
Thank you, Judge Cox. Okay, well, you all are familiar, I'm sure, with the principle that we look through the circuit court decision to the agency, but it's a little bit more nuanced than that. I mean, because the appellate court is going to search the record, and that obviously includes is primarily the agency record, to support the judgment of the circuit court, and will sustain that judgment for a reason that plainly appears on the record, whether or not the reason was expressly relied upon by the circuit court. So I just want to point that out. And oftentimes circuit court opinions are very, very helpful in explaining what the court's judgment relied on in the agency record. So it is important. We don't ignore the circuit court's opinion, and the more detailed it is, the better for us actually to do that job that I just explained. So I think, as Judge Cox said, we accord a high level of deference to agency decisions regarding matters that are committed to their discretion and expertise. But even when the agency's legal conclusions are premised on a matter of law, we will still give them a lot of deference to the agency's interpretations of a statute that it administers or regulations that the agency has promulgated. And I guess that's somewhat similar to what's known as Chevron deference at the federal level, which may not be around long, but for now, if the agency's interpretation is based on a permissible or reasonable construction of the statute it administers, it's entitled to great deference. However, when the agency's decision is premised upon application of case law, then it's a purely legal issue within the reviewing ken of the appellate court, and we will give no deference. Judge Cox is just referring to an opinion, a recent opinion, A+ Government Solutions, where we're reviewing a determination by the Maryland Tax Court. And in there, we explain that we do give greater deference to the Maryland Tax Court on matters of Maryland tax law, but we give no deference to the tax court's legal conclusions when it requires application analysis of cases and that are federal, interpreting the United States Constitution, or even the Maryland Constitution or Declaration of Rights. So there we give no deference. I just want to point out also that there are standards of judicial review that are also set forth in statutes. So, and that are apart from the APA. So for example, the General Assembly has codified some standards for judicial review for the Maryland Public Service Commission. I think it's Article, Public Utilities Article 3203. And it's very similar to what you find in the APA. And so it's largely consistent there, but it's more deferential in some respects. And that is what we look to when we are reviewing a decision by the Maryland Public Services Commission. So just be mindful that there are some statutes that actually set out a different and very specific standard of review for certain agencies. The one other thing I wanted to point out was, and this happens, we've seen this a couple times. There seems to be this view that we're on appeal from the circuit court. We can only review the issues that were raised in the circuit court. And that's of course not correct, because we're looking through to the agency's decision. And let me give you an example of that. We had a case, it was a tax case, and the agency denied this party an exclusion for filing their taxes. And the tax court had two grounds. One was a statutory condition precedent, basically like a jurisdictional issue. And the other one was a second part of the statutory analysis, that if you qualify for this exemption, then you have to show this. And when they appealed their case, the losing party in the circuit court, when they were arguing for their exemption, they only raised the second ground, which was not the threshold consideration, but the second ground on which this tax court issued its determination. And that was all that was addressed in the circuit court. And then we issued a decision reversing, because the tax court correctly determined that the party did not meet the statutory condition precedent to qualify for the exemption. That and the parties, sent us numerous, not just one, but several motions for reconsideration, arguing that they were denied their rights to due process because we considered issues that were not preserved and not presented in the circuit court, and this was unconstitutional. But we denied those motions, obviously. So I think that's all I wanted to point out. Thank you, Judge Cox.
I was having trouble unmuting. I apologize. This area, we talked about discretionary acts of an agency and the difference between Maryland and federal law on this. The wrap up on this generally is the bottom line of all of this is really to tailor your arguments to your audience. You have a very deferential standard of review in a trial court. One of the things I think trial courts like is that the appellate review is a look through the trial court and back to the agency. So you are going back to, it's not my opinion that's going up. It's basically a decision looking back through to the agency itself. And whether on review, whether that's to be affirmed or not. And as Judge Leahy said, I think the appellate courts look some passing mention to the trial court decision, but really that's not the focus. It's under the standard of review that applies whether the action of the agency is to be affirmed or reversed or remanded. So I know we're close to the end in terms of time here, and we wanted to leave some time for questions. I think the balance of this PowerPoint's been largely covered by what's been stated. John, why don't I kick it to you for questions so that we leave some time for people?
Great, thank you, Judge Cox and Judge Leahy for that. So we do have two questions in the chat. The first one, well, it's actually the second one, it's the most recent one. When does an agency have the right to defend its decision when it is challenged on judicial review? I'll take the liberty of answering that one. The agency is a party when the decision is challenged, so I mean, always has the opportunity to because it's sort of like saying, when does a defendant have the right to, challenge a plaintiff's lawsuit? So I think that one is a pretty straightforward one. Another question we've got is, in the federal arena, prevailing parties sometimes file to try and get a better forum than those opposing. Does this occur in Maryland? And I guess this is a question about sort of forum shopping, which is, a dirty word, but something that happens. I'll note on the federal side, when multiple parties file challenges to agency decisions in separate courts, there's actually a lottery system, and they get consolidated, similar to the multi-district process. So you don't always get the advantage you think you're getting. Meghan, I feel like you've had some experience with state court challenges being sort of selectively brought in one jurisdiction or another. Do you have any comments on the Maryland side of this question?
I was trying to think about this. It's where can you sue the agency, even if you are the prevailing party? I think that it typically would be, where is the agency's principal place of business, but I have to go back and look more closely. I think that there is some flexibility on where you can sue what is in effect the state, but I'm not quite sure I'm not quite sure about that. I haven't seen particularly people who prevail trying to, I guess, for lack of a better term, game the system by bringing a challenge in order to end up in a particular forum. Judge Cox, do you have a thought about that?
I've seen occasional venue motions where they have filed in a place where there isn't really venue based upon the residence of where the action arose, or a venue of a party on a, on a clear sort of jurisdictional review. So like an unemployment case, something of that nature, where the employment was in a jurisdiction, the person lives in a jurisdiction, they're filing in Baltimore County for whatever reason. There's some venue activity that goes on, but it's not very frequent. And largely because, again, if you go back to the numbers, geeky as that is, there's not a lot of this anywhere. So it's hard to figure out what's advantageous to you, because it's not like it's being litigated in large volumes and you can look at trends and kind of predict what's likely to occur one place as opposed to another.
So we just, well, it looks like I got a message. One of our audience members brought up an important nuance, that in cases involving the State Board of Education's review of local board matters, the state board is actually never a party, even though its agency decision is being reviewed. So that's an important nuance, and it does actually bring to mind a case I had at the Attorney General's office where it wasn't the State Board of Elections, it was the Public School Labor Relations Board, basically mediated a labor dispute involving a local board of elections. And the comment is exactly right. That board itself was actually not a party. However, when the case came to the Court of Special Appeals, it was granted leave to intervene. And so I think as a practical matter, if an agency is somehow not a party just by operation of law, I cannot imagine a situation where a court wouldn't allow the agency to intervene to assert its own interests, especially because certainly at the federal level, intervening is a very common aspect of administrative appeals, where sort of all the parties who had something to say at the agency will intervene, and I think courts are sort of used to that. So thank you for that clarification. But I do think that an agency is highly unlikely to be kept out of court. Let's see, we have another question. I thought the agency's right to participate depended on whether it was permitted by statute or if its quasi-judicial decision requires substantial discretion versus merely enforcing the requirements of a law or regulation. Well, I think what we are referring to is the enactment of quasi-judicial decisions or quasi-legislative decisions in which the agency is the party. I'm not sure about, I'm not familiar, and maybe others on the panel have a different view. I'm not familiar with the distinction that says that when an agency is merely enforcing the requirements of a law or regulation, if it's not challenging the actual enactment of the regulation, if you're maybe arguing that a regulation shouldn't apply sort of after it's been promulgated, I guess I'm just having a difficult time envisioning what that would look like, because you really only challenge the regulation when it's issued, and at that point, after that, it's sort of time barred. So I'm wondering if anyone else on the panel has a thought as to this question.
I mean, and you might see a circumstance where there's an enforcement action and that somebody within that enforcement action is challenging the constitutionality of the rule or the regulation that's being enforced. I mean, I could see it coming up not in the direct agency appeal context, but as a collateral issue in another law or claim. But then it doesn't fall within the category of cases I think we're sort of narrowly focusing on here, which are administrative appeals. I don't know.
But even in an enforcement action, I think the agency would be the party.
It's the party, right?
Yeah. Okay, well, I'm not sure how thoroughly we address that question, but are there any other? I guess we've got 4 minutes left if anyone has any additional questions for any of our panelists. I don't know, Angela, do we want to unmute at this point? And if anyone wants to just raise their hand with a question, or
Or folks can unmute themselves right now if they like.
Yeah, if anyone has a question that they want to just kind of shout out. And if not, I guess we can all go to lunch a few minutes early.
I've got a question. I got tired of trying to type it. So the slides, we seem to alternate between arbitrary and capricious level of review versus substantial evidence on factual issues. I mean, obviously, questions of law are de novo, but in the federal area, the OSHA statute specifically provides that the level of review by the Court of Appeals is substantial evidence. But on the other hand, the APA generally provides for arbitrary and capricious. But the slides seem to go back and forth between whether it was substantial evidence level of review or arbitrary and capricious. And so in Maryland, does it depend on the organic statute, or what accounts for that differentiation that maybe I'm just seeing and no one else is?
I wonder if maybe Megan or one of our judges has a thought on this.
I guess first of all, I tread lightly here because I can't give an advisory opinion, but I think that the opinion, we look to see that the decision of the agency is supported by substantial evidence. And we also look to see whether the agency's decision was arbitrary, capricious. I don't think that those are, they're not mutually exclusive concepts. I mean, I think that you can have one or both present in a case. And then again, I'm not sure in terms of the statute that you're referring to. Again, as I pointed out, different statutes may impose different standards of review for certain agencies that apply to judicial review and the appellate review. Am I addressing your question at all?
Well, I mean, traditionally, the substantial evidence is more deferential. Arbitrary capricious is more deferential to the agencies than, say, substantial evidence. And certainly the OSHA Act was written to be less deferential to OSHA than the APA provides generally for agency review. So, I mean, because Congress didn't trust OSHA at the time it was enacted in 1972. So they made it less deferential and empowered the courts to have a greater level of review over agency decisions, where the APA generally is perceived to have a more deferential level of review because of arbitrary capricious. So the general level of review in under the APA is arbitrary capricious, but sometimes the organic statutes provide that the court should be less deferential to the agency by providing a substantial evidence test.
I guess so, I don't know
say that.
But the APA also provides it that also says decisions must be supported by substantial evidence, right?
Yeah, and I guess I would.
Well, I think there's a difference between rulemaking and, of course, cases. Typically, in specific cases, the level of reviews can be substantial evidence. But I'm sorry, go ahead.
Yeah, no, I was just. I guess I don't quite agree that that arbitrary and capricious is sort of the standard level of review. I mean, it's one of certain enumerated at the federal. Under the federal APA, it's one of several enumerated sort of menu of arguments available to you. And substantial evidence, I think is, I'm not familiar with the OSHA standard you're referring to, but under the general APA, substantial evidence is really only a standard for adjudications, not for rulemakings.
Right.
And then in the Maryland system, you still have those enumerated bases for when you can reverse an agency decision, and you kind of have to trace the standard back to what decision it is. So if you're in, if it's a quasi-legislative act, you have, you don't have really enumerated bases there. You look at arbitrary and capricious, which the federal, the state version of arbitrary and capricious tends to be a little bit more narrow than federal arbitrary and capricious. It really sort of focuses on the scope of the agency's authority. If it's an administrative mandamus, you have by rule you have certain menu of options, and likewise for a contested case. So there's not a uniform application of standards to all standards don't necessarily apply to all categories of decisions.
Okay, thank you.
I'll just add one note that there's a recent decision that was issued in the Court of Special Appeals by Judge Friedman that I think that helps deal with this a little bit. It's Prince George's County Department of Social Services versus Taharaka, in which both the substantial evidence standard and the arbitrary capricious standard were applied to reverse factual findings of the agency.
Oh, interesting.
Well, it looks like we've exceeded everybody's time by 2 minutes, and so I don't want to intrude on any more of the panelists' time. So I'll thank everyone very much for their participation today, and thank you all for attending. And we hope you found it interesting, and it was a pleasure to get to put this presentation on for you.
Thank you.